So,
Okay.
welcome to this edition of Meet the Candidate, David. It's been a long time since we've seen each other, and we just started getting caught up. And I said we've got to record this because it sounds like an interesting story. So, tell me about how you ended up working on the Colville Reservation.
Well, I was working as an international prosecutor in Kosovo. And so I got an email from the Colville Confederated Tribes because I'd put in to be their chief prosecutor. And they said they wanted to interview me. And I'm always willing to do interviews. So I said, sure, I'll do an interview. So we did an interview, and they said they needed a public defender. And I said, oh, I've always been a prosecutor. That's kind of what I've been doing for the last, I think it was 13 years at that time. And I said, you really don't want me. I've got some friends who are public defenders who might be interested that are in that area. I'll give you their names and phone numbers. And they said, no, we want you. And I said, why would you want me? And they said, we've never seen anyone that's done that many jury trials. And so I said, well, maybe I just don't know how to settle my cases. Maybe that's not a good thing. Because I don't know if you remember when I was a prosecutor in Spokane County for the state, they used to call me No Deal Dave. So because I went to trial more than anybody reasonably would. Yes, what can I do for you? Oh well. So let's see, where was I at? So I said, no, you probably don't want me. And I said, and they said, well, what do you know about Indian law? And they said, I said, I would like to say I know nothing, but I probably think I know some stuff about it, and I'm probably wrong. So I put it at minus 10, minus 20%. And so finally, just to get them off the line, because I wasn't really interested, I said, by the way, there's no way you guys could afford me. The first $100,000 I make is tax exempt since I'm overseas. And they said, do you know how much we pay? And I said, no. And then they told me how much they paid. And I said, I can be there in about 4 weeks. And so, plus, I was kind of intrigued. I'd never been a public defender. You know, I was really good as a prosecutor. Sent a lot of bad guys to prison, resolved a whole bunch of cases for people to get treatment. And so, but I didn't know how I would be as a public defender. And then I don't know if you remember the Gerlach trial. That's
Vaguely.
where, yeah, Glenn Gerlach, a guy was stealing his truck. He shot the guy in the back of the head. Uh, so he was being charged with manslaughter. And I was the defense attorney. That was private defense on that case. And so I needed to come back. I was going to take vacation from my Kosovo job in Eastern Europe, go back, do that case. And so that kind of coincided. And so I went, I took the job for the Colville Confederated Tribes. And it turns out I was exactly right because I thought I knew some stuff about Indian law and I was wrong. So this is what I find fascinating. The Bill of Rights does not apply to tribal courts.
Really?
And you think about it, because the Bill of Rights originally only applied, the first 10 to the federal government. And then through the 14th Amendment, we incorporated the Bill of Rights. And we still haven't incorporated all of them. So it's never been addressed whether or not the states could quarter troops.
Hmm.
Third Amendment. It's never come close to a couple of times having cases, but that's actually never been incorporated. But all the rest of it, yes. What? So, yeah, and it doesn't apply. So they have the Indian Civil Rights Act of 1968 as amended by the Tribal Law and Order Act of 2010. So the two things that are in the Bill of Rights do not apply to tribal courts are one, religion. They can have religion involved in their tribal governments and in their tribal courts. And it makes sense. And then the second one that I always found incredibly fascinating is the firearms. They can prohibit firearms on a reservation.
Hmm.
I don't think any tribe has ever done that or will do that because the hunting tradition on
Mhm.
tribal reservations is quite strong. And the right to a jury trial is different too. you have to demand the right to a jury trial. So if you don't demand it, you automatically get a bench trial. So and it became a really fascinating job. I was really good at it. And the reason why they said they needed somebody with that much tribal experience is they had a whole bunch of new deputy prosecutors, and they said that they needed somebody who could keep them in line. There's only one person in a tribal court that has to have a law degree. Who do you think that would be? There's the judge, there's the prosecutor, there's the public defender.
The judge?
No, no. So when they passed the Tribal Law and Order Act, as well as the Indian Civil Rights Act, they were very, they had done studies and they found out the due process wasn't being ordered in tribal courts. And at first, when they did the Tribal Law and Order Act, they wanted everybody to have a law degree, but the tribes, and this is correct, that would just cost them a fortune.
Mm-hmm.
It'd be insane how much they'd have to spend if everybody had to have a law degree. So what they did is they said, well, the public defender has to have a law degree because the public defender will hold everyone to account.
That actually makes sense.
Yes. And what's another interesting thing about Indian law, I can talk about Indian law all day long, but Indian law is if, say, a tribe's violating your due process rights, they're doing something they're not supposed to be able to do. The only way to get to federal court to get it fixed is by habeas corpus. So you have to say that I'm being illegally held. And then when you get there, there's no injunctive relief. So say the federal court says, yeah, they violated your rights. They're violating everybody's rights. They can't tell the tribal court, stop violating people's rights. They can just release that one person. I think that's a real weakness in the in Indian law. But yeah, fascinating stuff. In fact, I did the job for 3 years, and then they were violating the Tribal Law and Order Act by not having an evidence code. And so what they do is they're limited to misdemeanors in tribal courts. So what they would do is they would stack them. So you got 3 counts. They could send you away for 3 years. One guy got 7 years, 7 different misdemeanors, all one run after the other. But in order to stack sentences, they need to comply with the Tribal Law and Order Act. And they weren't complying with that. And it took me 2.5 years to get a case up to the Court of Appeals, their Court of Appeals. And the Court of Appeals found, yeah, they were violating it. So a whole bunch of people had been sentenced to more than 1 year. Their sentences had to be reduced to 1 year. It turns out that a lot of people were really mad at me because these guys who had gotten several years in tribal jail, and sometimes they would be transferred to federal prisons, they had to be let out. And so my contract was not renewed.
Because you were good at your job.
Well, it depends on who you ask. I'm not sure. I'm not sure some of the tribal members saw it that way. In fact, they said when they wouldn't renew my contract, they said, well, you're getting people out on technicalities. And while it isn't quite apt, because the way people understand the law, I said, well, if you believe complying with the Constitution is a technical matter, I guess you're right. But yeah, so I did that. Then I ended up going to Okanagan County, where I ended up being chief criminal prosecutor. The prosecutor resigned, and they appointed somebody. So you know how it works when the prosecutor resigns. It goes to the PCOs of the party which the prosecutor belonged to. So we went to the PCOs, and 76% of them said I should be the prosecutor, and 24% said another person. So the county commissioners in Okanagan did an interview. They actually taped it. It's out there in the internet somewhere on YouTube. And I went in, I said, listen, if you don't fund the office properly, give me more money for attorneys, because Okanagan's kind of geographically isolated. So it's very difficult to get attorneys. Then I'm not going to be able to prosecute certain cases, ones that don't involve violence and things of that nature. And the other person, who only got 24% of the PCOs, said, no, everything's fine. It's just a matter of efficiency. So they appointed her, and I do not blame them because I was going to cost them a lot of money if they had appointed me, or some crimes weren't going to be prosecuted. In fact, that's what's going on, and is accelerating in all of Washington, which we'll get to why I'm running. So then I ended up coming to Mason County. I was a senior felony prosecutor in Mason County, and so I actually had a better job as chief prosecutor for the Ute tribes. They paid a lot more, had much better benefits. They had all kinds of resources for me, and they were very few cases. But Mason County, I'd put in an application that I'd forgotten about. And so they made me an offer, and I went to my wife, and you know my wife, Pam. So I go to Pam and I said, hey, they're offering me less money, a lot more work. I'm going to be grumpy all the time. And she says, why would we want to go to Mason County then? And I said, that's where our oldest daughter, Samantha, lives. And we had 3 grandchildren then, and now we have 6. And she said, take it. And so we moved to Mason County, and Inslee appointed this very liberal judge. And so she made some just terrible decisions regarding criminal cases that I was on. And so I was asked by a lot of people to run against her. And you know that it's very, very rare that these appointed judges ever get anyone to run against them. And if they do get somebody to run against them, it's even rarer that somebody will defeat them. So I beat her by 15 points, and I became a superior court judge in Mason County. And that's what I do right now. So, and that leads to why I'm running. So you've heard about the caseload limits. You've seen some stories,
right,
and things like that. That is going to wreck county budgets, and it's already having an effect in several counties. So we're slated to have 3 public defenders in order to comply with these caseload limits. And at first they'd set them at 147 felonies. And I'm talking about Superior Court, and it applies to District Court too, but 147 cases. And that was doable. That could work. It kind of comported to what most offices had for public defenders. But then they decided they didn't like the results. They think too many people are being convicted, too many people are pleading guilty, that this affects minorities, racial and ethnic. So they lowered it to 47. So now we figure we have to go to 8 or 9 public defenders in order to comply. And they're all attorneys. They've got to have support staff, larger building, IT, health benefits. This is going to take the Mason County budget, and we figure it's going to increase probably, I've heard as high as 8 million, but I think that's excessive. But I think 5 million, and that's going to blow a hole in the budget. And the problem is and you can tell this is a policy decision, and the courts, we don't do policy. So we decide whether or not a law is, in contradiction to the Constitution, or if a statute's being interpreted properly. We're not policymakers. That's what the legislature does. So they said for the smaller counties that this could be implemented 10% every year to 100% in 10 years. And everybody told them that's not going to work, because counties that have a lot more resources, say King County, Thurston County, they're going to go to full implementation. And so not only will these people, because they've been historically paid more because these counties had more money to pay public defenders, now you've got places like Mason County that will pay you less because we don't have the resources to compete pay-wise. But you're going to have 120 cases, whereas if you go to one of these other jurisdictions that's in full compliance, you will have 47 cases. That's a no-brainer if you have the option to go work in those. And so full implementation, and I don't know if you're aware, the public defenders in Spokane County are suing Spokane County because they haven't gone to full implementation. So
I know. I'm familiar with my county, which is Lincoln, which is one of the rural counties that our commissioners are trying to figure out how to do this.
Yeah, they're gonna have to blow a hole in the budget. I mean,
Mhm.
where are they gonna get that money from? Either they're gonna have less services, but I don't want to get into the policy because that's not what courts do. So, and
So
then
your wrap up of why you are running for
uh,
Supreme Court Justice position number 3
all
and
right,
make your pitch.
all right. So it's not just that. So the Washington State Supreme Court has decided through its rulemaking administrative process that it's going to change the laws. So they did away with our ability to issue warrants for juveniles when they violate their probation, unless we can make a specific finding that there's an actual danger to someone, which is very rare. So if a kid has a drug problem, I mean, I would have these 14, 15, 16-year-old girls that were being abused by men, hooked on drugs, committed crimes. We'd put them on probation, get them clean, work with them. If they didn't stay clean, put a warrant out, and then they'd have to be incarcerated until they got into compliance. And so they eviscerated that. They're trying to do away with bail for adults, and that would be a long discussion. But they have decided that they can use their rulemaking to change the entire criminal justice system in Washington State. Decisions like the Blake decision that legalized drugs, that decision is a travesty. If you read that decision, it doesn't make any sense. It had been up to the Supreme Court twice before. And then that's how you got the rampant drug use that you can see if you walk the streets of Seattle. I mean, they've decided they're going to change the entire criminal justice system. And the reason is because they're ideological. Last 40 years, we've had the governor appointing judges. So 70%, and that's the low end. It fluctuates. It's high of 83%, low of 70% of all the judges, Superior Court, Court of Appeals, Washington State Supreme Court, are appointed by the governor. That was never meant to happen. When we did our state constitution, they specifically did not want the governor routinely appointing judges because there had been problems under the territorial government with judges being appointed and acting politically. So what we've had is a tradition that is propped up where you're appointed by the governor. Because you were appointed, you resign before your term is over, and the governor gets to appoint your successor. Then there are incumbents, somebody runs against them, and then it's very unlikely, as I pointed out earlier, for anybody to defeat them in an election because they're incumbent. They're wearing a robe. Nobody knows anything about them. We're not allowed to take political positions or say how we would decide cases. So there was an open seat for the state Supreme Court. I think we need to get common sense, somebody who will follow the state constitution and the federal constitution and won't be a policymaker, so that we can call the Washington State Supreme Court to account and let the public know what's going on. Last time we had anyone who disagreed ideologically with what's on the Washington State Supreme Court was 2011, and it was Justice Richard Sanders who's endorsed me. So it's a real problem. We have an ideological court now, and it needs to stop. And we need to elect people who are not ideological, that will follow the law and not be policymakers. So that's why I'm running.
Okay. Well, thank you,
Okay.
David. Wish
Real
you.
pleasure to meet up with you again.
Yeah,
So
yeah. It's
been a minute.
it's been a couple decades since we used to bump into each other
I
at
know
events around Spokane County.
Pam and I were talking because she saw that I was doing this interview, and she said to say hi.
Yeah. Okay. Well, hello back to her, and I'm glad you're near your grandchildren.
Okay.
All
Talk to you
right.
later.
Thanks. Bye.
Bye.